Good afternoon, everybody. It's terrific to see this wonderful turnout for the second major event of the Indiana University Maura School of Law LGBT Advisory Board. Last year, we inaugurated this board with a terrific event on marriage equality for same-sex couples, and today I'm delighted to continue that conversation as the legal arguments that underlie it continue with today's mini-symposium on same-sex marriage and the future of DOMA, law, politics, federalism, and families. Today we'll talk about lawsuits challenging the Federal Defense of Marriage Act and recent controversies over whether the federal government should continue to defend the act. And I don't think we could have a better set of discussants for that topic. All of us here at the Maura School are deeply grateful for the opportunity to host the event. We're situated on a campus that provides such rich resources for having a robust conversation on this issue. And we can provide a forum for scholars and lawyers and students and community members to discuss the future of DOMA in light of serious challenges to its constitutionality. I'd like to start by thanking the sponsors of the event, the Maura School of Law LGBT Alumni Advisory Board, the IU College of Arts and Sciences, the IU Office of Affirmative Action, the IU GLBT Alumni Association, the Center on Law, Society, and Culture, and Outlaw, the law school's LGBT student organization. I'd also, if I could, like the members of our LGBT board here at the law school to stand up for our welcome and thanks for a moment. Thank you very much. And I'd especially like to thank a founding member of our board, Steve Sanders. Steve is a longtime IU person, currently at the University of Michigan Law School. He's kind of a force of nature. He has been so helpful to the law school and the IU community in organizing events on these important civil rights issues. So Steve, welcome back to the law school. And I'd like to invite Steve up now to introduce our spectacular panel.
Thanks to all of you for coming and for your interest in this program. We also, in addition to a full house here, are joined by colleagues and friends at the IUPUI campus. That's what some of this technology is for. The event is being webcast. It will be archived on the web for those of you who have friends and colleagues who couldn't be here but who'd still like to see the program. And we welcome a group in Indianapolis at the IUPUI campus that was organized by their LGBT faculty and staff council that's joining us remotely as well. This program could not have been possible without Dean Robel's initiative to create the LGBT Alumni Advisory Board or without her steadfast support. It also would not have been possible without the hard work and dedication of some key members of her team here at the law school, especially Andrea Havel, Ken Turchi, Michael Keller, Nikki Rolfe, Catherine Dyer, Frank Burley, and Marion Conity, all of whom put up with my questions and suggestions and fretting over the last several weeks. Our program today is about same-sex marriage, but I hope you'll find it's really about more than that. I hope you'll find that it explores how law affects human lives, how law both shapes and is shaped by human attitudes. This topic shows how politics begets law and how law drives politics. It highlights questions about the respective roles of the state and federal governments and the diversity of our federal union of states. And it forces us to think about the ideas and the actors who shape what our Constitution means in practice. Our special guest today, Maura Healey, has served since 2007 as the chief of the Civil Rights Division in the Office of the Massachusetts Attorney General, Martha Coakley. During this time, Maura has overseen investigation and prosecution of civil rights cases in such areas as mortgage lending, housing, education, public accommodations, health care, and hate crimes. Most significant for our purposes today, Maura is the lead counsel in Commonwealth of Massachusetts versus U.S. Department of Health and Human Services, that state's groundbreaking challenge in federal court to the Federal Defense of Marriage Act. Prior to joining the Attorney General's office, Maura was an attorney with Wilmer, Cutler, Pickering, Hale, and Dorr, where her practice focused on complex commercial litigation, securities litigation and enforcement, and government investigations for a range of companies in technology, life sciences, and pharmaceutical areas, as well as professional sports teams. She was also involved as a private attorney in the representation of military personnel challenging the government's don't ask, don't tell policy, and a challenge to the application of a state law that restricted the ability of non-resident same-sex couples to marry in Massachusetts. In addition to this program this afternoon, tomorrow Maura will have lunch with some 36 undergraduate students from political science, the Wells Scholars Program, the Honors Division, and the Political and Civic Engagement Program. So Maura, thank you so much for being with us today to talk about one state's challenge to the Defense of Marriage Act.
Thank you, Steve, for that kind introduction, and Dean Robel, and all of you at the Maura School of Law and sponsoring entities. It's a real pleasure for me to be here with you today and to take in your beautiful, beautiful campus. I've long wanted to venture here, and this provides a wonderful opportunity. So I'm going to talk today about our state's challenge to the Defense of Marriage Act, and to do that, I want to start by giving you a little bit of context. In 2003, a group of same-sex couples in Massachusetts sued the State Department of Public Health, claiming that the department's marriage licensing laws, which prevented gays and lesbians from getting licenses, violated our state equality and liberty interests in our Massachusetts state constitution. Well, the Massachusetts Supreme Judicial Court agreed and said that without access to marriage, same-sex couples were, quote, excluded from the full range of human experience and denied full protection of the law. It then gave the state legislature 180 days to correct this constitutional infirmity. The legislature came back and proposed civil unions. The Supreme Court said that doesn't cut it. And at the stroke of midnight on May 17, 2004, gay and lesbian couples began to marry in Massachusetts. From that day forward, our state has recognized a single marital status open to every qualifying couple, whether they're of the same sex or different sex. The decision, which was debated nationally and internationally, was also the subject of controversy within our state. But at every turn, efforts to undo that decision were rejected. A year following the Goodrich decision, there was a proposed constitutional amendment to ban same-sex marriage. It was overwhelmingly defeated by legislators at that time. 2 years later, there was a citizen-initiated petition to institute a ban, and that too failed. And so today, 6 years following that decision, there are now over 16,000 couples in Massachusetts who have married. This has been a very positive development, obviously, for those families, many of whom have children. They're afforded greater stability and security. They've been more accepted by their community and by their families. Their children, reports are, feel happier and better off with their parents married. And all of this has been borne out by research that our state has conducted. One study that I'm always struck by is that in the years following the legalization of same-sex marriage, gay people have experienced statistically significant decreases in medical and mental health care visits and diagnoses of depressive conditions. But beyond the impact on those couples and those families, people in communities across Massachusetts came to see through the everyday encounters with their neighbors, co-workers, friends, and family members that gay and lesbian people are just like everyone else. And for all the predictions that allowing same-sex couples to marry would erode or weaken the institution of marriage, Massachusetts marriage rates have continued to increase and remain high, and our divorce rate remains the lowest in the nation. So sure, there was debate and controversy and moments of division and rancor, but put simply, our families, our communities, our state, even our economy has been made better and stronger by ending discrimination against gays and lesbians. And it's not surprising to me that there are now 10 other states that either license or recognize marriages between same-sex couples. So from my perspective, that's the good news. The bad news is what Goodrich brought into sharp relief, which is the very real harm caused by DOMA, an unprecedented, discriminatory, and we submit unconstitutional law. Let me tell you briefly what DOMA does, and for that I need to take you back to 1996, when the Hawaii Supreme Court ruled in Bear versus Lewin that refusing to grant marriage licenses to gays and lesbians was sex-based discrimination. Now, the licenses didn't actually start to issue in Hawaii because the court sent it back to the lower court for further proceedings. This gave time, of course, to the Hawaii state legislature to pass a marriage ban, and it also led to Congress's passage of DOMA. DOMA does two things. Section 2, which is not at issue in our litigation, created an exception to the full faith and credit clause and established that no state would be required to recognize a same-sex marriage conducted in another state. Section 3, which is at issue in our litigation, creates a national definition of marriage limited to the union between one man and one woman. Now, at the time DOMA was enacted, of course, no state was actually licensing marriages to same-sex couples. Instead, what DOMA was doing in 1996 was prospectively invalidating marriages between same-sex couples for purposes of any and all federal laws, regulations, agency interpretations, and the like. Now, what did this mean for Massachusetts couples? Well, our Federal General Accounting Office has identified over 1,100 places in law where marital status is used to determine the eligibility for benefits, rights, and protections. They cover a wide range of areas, including the workplace, health care, taxes, Social Security, retirement, bankruptcy, copyright, even court proceedings. Because DOMA applies to every federal law, some of these things have to do with spending and spending powers of Congress. Many of these things do not. But collectively, DOMA touches every aspect of a person's life from the time they are born to the time they die, and even beyond the grave. Here are just a few examples. Next week we'll all be paying taxes. Well, spouses are permitted to file joint tax returns and to pool their deductions. The value of health care coverage for your spouse is not counted as taxable income. Social Security. Spouses are entitled to higher benefits upon the retirement or death of their spouse. And surviving spouses receive one-time lump sum death benefits. In the workplace, if your spouse is sick, employees are guaranteed leave to cover, guaranteed time and leave to care for their spouse. They can enroll their spouses in health plans outside of open enrollment periods, and spouses are automatic beneficiaries of annuities and pension plans. Spouses of firefighters and police officers and veterans have other rights, including tuition fees, important death benefits, and health care coverage. These are just some of the examples. The list is really quite breathtaking in its scope. But the bottom line is, if you're married and you're gay, you are excluded from all of these. So this is how we saw DOMA hurting families in our state over the last 6 years, even though they had received the very important right to obtain a civil marriage license. But we also saw firsthand how DOMA was hurting our state as a state. First, DOMA was imposing a national definition of marriage over our own state definition, Remember, I said that we have a single category of marriage in our state. You're married or you're not. It doesn't matter if your spouse is of the same sex or the opposite sex. Now, DOMA was a direct interference with that state definition and with our state's long-standing sovereign authority to define and regulate the marital status of our citizens. Second, DOMA requires Massachusetts to discriminate against one category of married persons, persons who have same-sex spouses, when it administers jointly funded state and federal programs. And I'll talk about that a little bit later. Third, DOMA requires us as an employer to discriminate against our own state workers. Let me explain. We have over 500 state employees who have their same-sex spouses on their health care plan. Now, we have to treat that health care coverage as income for that employee. So next week, when people go to file their taxes, they are going to be charged incrementally more income for the cost of their spouse's coverage. And this is of no small consequence when you're talking $3,000 to $4,000 to $5,000 to $6,000 to $7,000 each year to maintain their spouse in their health care plan. We don't do this for other married employees. Fourth, DOMA puts Massachusetts state agencies in an impossible, and we submit unconstitutional, dilemma. We're in the position of having to choose between complying with the mandates of federal programs that require us to disregard marriages of same-sex couples, or else risk losing federal funding if we go ahead and treat all married couples the same. And the consequence of that is of significant magnitude, on the order of billions of dollars each year for our state alone. And finally, as our various state agencies have tried to comply with DOMA, but at the same time respect the Goodrich decision and ensure equality for all of our residents, we've been forced to incur administrative, human resources, accounting costs in trying to keep track of a category of persons who are married for purposes of state law but federally single. So it was in these ways that we believed that we as a state were really being harmed by this law, in addition to the real grave harm we saw being done day in and day out to families in our state. So this gets me to the point about our role as Attorney General and why we decided to bring this lawsuit. Now, back a few years ago, we knew that the legal advocacy group, Gay and Lesbian Advocates and Defenders, the ones who were responsible for bringing the challenge that resulted in the Goodrich decision, were prepared to challenge DOMA on direct equal protection grounds. They were going to be filing a case on behalf of some individual married couples in the state. Well, we talked with them about that, and we thought and believed very strongly, as we do today, that a state has a role in that discussion. The Attorney General's office has three roles. The first role is to protect the public interest. By statute, we are to take cognizance of all violations of law affecting the general welfare of the people, and we are to institute civil proceedings before the appropriate state or federal court as we may deem to be for the public interest. Very simple. Most days, as Steve mentioned, we're in the business of bringing suits against real estate agents, employers, businesses who discriminate. That's what we do in the Civil Rights Division. Well, it's very hard for us to be doing this work, but to look the other way when the federal government was discriminating. When married same-sex couples and their families were being denied access to critically important rights and protections. The second interest that we have is to represent and protect the interests of our state agencies. Here, as I mentioned, our state agencies are being made to enforce and implement day in and day out a discriminatory law. And in doing so, we're threatened with the risk of loss of federal funds if we don't comply with DOMA. This puts us in a very difficult place where agencies are burdened with having to choose between applying a state definition of marriage or applying DOMA's federal definition. Third, the Attorney General's prerogative is to uphold and protect our sovereign interests and to uphold state and federal constitutions. Here, our marriage definition and our ability to regulate marriage by including same-sex couples is being challenged, and we believe in an unconstitutional way by DOMA. So in taking on DOMA, for us as an Attorney General's office, this was very easy. On all three counts, on all three Attorney General prerogatives, DOMA was advancing those goals and that mission. So we began to draft a complaint. And at the same time we began to draft the complaint, we began to prepare a record. We anticipated that the government would quickly move to dismiss our case, because there have been other DOMA challenges in the past, and that's what's happened. And we believed that in opposing the motion to dismiss, we would simultaneously move for summary judgment. And for all of you civil procedure folks out there, you know that to do that, it's very important to establish a record of undisputed facts. And so we worked for a year or more on that, spending a lot of time with our state agencies, understanding exactly how DOMA was being implemented on the ground, where it was costing us money, where it was causing us hurt. And finally, in July of 2009, we brought a case in the United States District Court in Boston challenging DOMA. The case was filed as a case related to the Gill case, which you'll hear more about from others later, which was the equal protection challenge on behalf of individual plaintiffs. Now, as a state, many of you probably know, we don't have standing, we don't have the authority to bring a direct equal protection challenge. But we conceived of our case in a different but complementary way. For us, this was really a case about federalism and Congress overstepping its bounds when it passed DOMA. For us, the question presented was simply this: does Congress have the power to create a federal marital status, a national marriage law? To us, the answer is no. Here are the two claims that we brought. The first claim we brought was a claim under the 10th Amendment. You may remember that the 10th Amendment says that all powers not delegated to the federal government are left to the states. Well, in our view, defining and regulating and setting the rules for marriage is something that has been left to the states since the founding of this country. And even when you go back into sort of colonial and pre-colonial days, that was the case. DOMA violates the 10th Amendment because it intrudes on our state sovereign power to define and regulate marriage by creating a federal marital status and by basically eviscerating Massachusetts' definition and category of a single marriage status, dividing that category into two: persons who are married for purposes of state and federal law, and persons who are married for state law but federally single. Now, I say this is a state power. How do I know this? It's very simple. If you look back at the necessary division of power and division of labor between states and the federal government since the time this country was founded, it's quite clear that for the past 200 years, states using their police power have made the rules for marriage, and the federal government has always deferred to and accepted state definitions of marriage. Remember, you get your marriage license from a state, not the federal government. And the Supreme Court has said as much. If you look at the long line of unbroken cases, beginning with In re Burris and Haddock from 1906, where the court is talking about that the states at the time of the adoption of the Constitution possessed full power over the subject of marriage, and that the Constitution delegated no authority to the United States government on that subject. That concept has been upheld by the Supreme Court in a long line of decisions. Even most recently, decisions in the last 15 years where the Supreme Court was looking very closely at the division of power among states and the federal government in cases like Lopez and Morrison. Now, some of those are Commerce Clause cases. That's not the provision at issue in our case, but they nevertheless set forth a pretty clear delineation that in the area of domestic relations, the primary determiner of laws are the states. And within the very narrow category of defining and regulating marriage and setting the rules for marriage, it's states that have that power. So, to the extent the federal government wants to make certain benefits or rights or protections, in addition to obligations and responsibilities, turn on marital status, it should do what it has always done, which is to look to and rely upon state determinations of marriage. You may have noticed, if you've looked at some of our papers, that the court was very persuaded by one affidavit we submitted in particular from a Harvard history professor, Nancy Cott, who basically set forth the history of marriage in this country. And what she pointed out to the court was that over time, state marriage rules have changed substantially and evolved substantially over time. And there's been a lot of variation among states over issues like race, consanguinity, disability, and even common law marriage. And while at times these divisions and differences have been politically and socially extremely contentious, I mean, if you go back in time and you look at proposed changes to state marriage laws that permitted interracial marriage, or even changes that for the first time allowed no-fault divorce, these were incredibly contentious, politically debated, socially discussed subjects, and they were fiercely resisted as threatening the institution of traditional marriage at that time. But in every single instance, despite all of the debate and all of the variations, the federal government consistently and uniformly accepted state marriage determinations until DOMA. And you know, Congress, I find it interesting to look at the House report from time to time back in 1996 when DOMA was being debated. And even in the House report on the DOMA debate, Congress acknowledged that itself. It said, and I quote, "The determination of who may marry is uniquely a function of state law. That has always been the rule." It's also what the Congressional Budget Office told Congress at the time. Quote, "Under current law, the federal government recognizes marriages as defined by state laws for purposes of providing certain benefits to spouses." That was at the very time that DOMA was being debated. Congress knew that this was an issue for the states. Never before, as I said, until DOMA, had the federal government gotten involved with marriage determinations in this way. Never before had the federal government rejected a state's definition of marriage. All we were asking for in our 10th Amendment claim is that the federal government return to doing what it has always done, which is to accept a state's determination. We weren't telling the federal government that other states had to accept the marriages of same-sex couples, and finding for us wouldn't require other states to do that. All we were asking is that when the federal government uses marital status in federal laws, that they do so in an even-handed and neutral way. The second claim we brought is something called the Spending Clause. How many of you in the room are familiar with the Spending Clause doctrine? South Dakota versus Dole? All right. Well, basically, the doctrine... That's all right. Basically, the doctrine is this, okay? The federal government can give out money, and it can give out money to the states, and the states gladly accept that money. However, in doing so, the federal government can require states to comply with certain conditions in order to receive those funds, as long as those conditions are proper. And the test that was set forth in that case is asks the question of whether the condition that the federal government is imposing causes a state to violate the Constitution. Okay? So our argument, for example, is that the federal government may give states money to build schools. However, it cannot say to the state, build schools for white children, but not for African American children. Or it can give money to the states for health care coverage, but it can't say, provide that coverage to women, but not to men. Okay? So that's the concept of the spending clause. And so, to our mind, DOMA violated the spending clause because when the federal government was giving us money for programs like Medicaid or Veterans Services or other programs where some of the money comes from the federal government and then the state kicks in some portion to provide services. When the federal government was doing that, it was doing that with the requirement that the state enforce DOMA and disregard marriages of same-sex couples. And in this way, DOMA was forcing Massachusetts to violate the Equal Protection Clause of the United States Constitution by forcing us to treat some category of married persons differently from another category. Let me show you in real concrete terms what we mean by this. As I mentioned, we have a program related to veteran services, and one of the aspects of the program permits the burial of men and women who have served our country and their spouses in cemeteries run by the state. And the federal government gives us money to do that. However, the condition imposed now is that we cannot bury the same-sex spouse of a veteran. And if we go ahead and we bury that spouse, the cemetery is no longer being operated for the benefit of veterans and their spouses, because remember, a same-sex spouse isn't really a spouse in the eyes of the federal government. So if we go ahead and do that and bury that person, we lose all of our veterans services funding. Now, this wasn't a hypothetical for our state. This was very real. We had a gentleman who served for nearly 30 years for our country. He served with distinction, bronze medal winner, won a lot of different distinctions for his work in intelligence. And when he came out of the military, he ended up getting married. And he and his spouse applied recently for permission to be buried in one of our veterans' cemeteries. Now, for the state, here was the unconstitutional choice. Go ahead and accept DOMA, comply with DOMA, and reject this guy's application. Refuse to bury this veteran and his spouse. Or we could agree to honor his service to the country and bury him and his spouse, but in doing so, violate DOMA. And for us, the risk and the harm in doing that is that the federal government told us explicitly in correspondence, because we did write to them this, that we would risk federal funding, that they would come in and take funds away, not only for the burial program, but for all of our veterans services. So how is it that keeping a veteran's spouse from being buried with him in a graveyard honors our veterans? What purpose does that really serve, other than to, as the district court found in our case, do anything other than, quote, perpetuate heterosexuality in the graveyard? We think he understood the issue. And the same was true for Medicaid. I won't go into that example with you, but suffice it to say that Medicaid funding rules would have the perverse result of requiring us to extend Medicaid coverage, which is intended for low-income and needy individuals, to affluent same-sex couples. Because remember, they're not actually married in the eyes of the federal government, so you look at each spouse individually and make those determinations. At the end of the day, what we concluded is that DOMA was serving no benefit other than to punish gay people and their families. It's discriminatory and it's unfair. And by forcing us to treat couples differently from same-sex couples differently from straight couples, DOMA was forcing us to violate the Equal Protection Clause and therefore forcing us to violate Dole. Let me just turn quickly to that analysis. In the concept of constitutional law, when it comes to equal protection issues, where you're treating one category of persons differently from another, you have to consider the interests being advanced in that distinction, okay? And Congress said at the time it passed DOMA that there were 5 interests. First interest was to, quote, encourage responsible procreation and child rearing. Okay, that was the first interest in DOMA. A response to that is, well, if that's going to be the rule on marriage, then we shouldn't allow infertile people to marry. We shouldn't allow people over a certain age to marry, right? If that's in fact the interest. The second interest advanced was defending and nurturing the institution of traditional heterosexual marriage. As I said earlier, in Massachusetts, at least same-sex marriage hasn't resulted in a slowing down of heterosexual marriages. In fact, the marriage rate still remains high. And we've not been able to understand how it is that allowing a same-sex couple to marry prevents straight couples from marrying. The third interest is protecting state sovereignty. Good, you get it, right? That's why we have a case. The fourth interest was preserving scarce resources, okay? Scarce government resources. I don't really understand this. At the time that DOMA was considered, Congress specifically rejected an invitation by the Congressional Budget Office to do a fiscal analysis of DOMA's effect, okay? Said, no thanks, we actually don't want to know. Even though preserving scarce government resources is an interest, we actually don't want you to look into that. Well, you know, a few years later, the CBO did. And you know what it found? It showed that DOMA actually costs the federal government money. Finally, the interest advance was reflecting and honoring collective moral judgment about human sexuality. And we know, I believe, after the Lawrence decision, that this really won't hold water as a legitimate government interest. So we submitted record evidence as to why all of these interests fail, and why, when stripped to its essence, DOMA really is all about animus towards gay and lesbian people. There is no other interest served. Now, the Department of Justice, in defending our lawsuit, came up with some additional interests, okay? And it's allowed to, if it's looking at this under rational basis review. But on that point, you know, rational basis for those who've had con law or in con law right now, you know that rational basis review is the most lenient level of review. But it's not toothless. It does mean something, actually. And just saying that something is a government interest doesn't make it so. There is a certain smell test that has to be passed here. And for us, if you just scratch the surface of some of these purported rationales, even just a little, you'd see that they're irrational and that they're not supported by law or fact. The three rationales recently advanced in support of DOMA is that, on the one hand, it's going to support the status quo, okay, and preserve the status quo, because at the time that DOMA was passed, no state recognized same-sex marriage. Well, we believe that DOMA directly undermines the status quo, because the status quo in 1996 was that states get to determine marriage and the federal government accepts that. And really, if status quo is legitimate, no historically discriminatory law would ever be struck down, right? The second interest was incrementalism, this notion that we need to sort of move slowly and let the states consider this one by one and see how this all unfolds. And for us, incrementalism is not an end in and of itself. And really, at the end of the day, there is nothing incremental about DOMA at all. Remember, it's a complete and total ban on recognition of same-sex marriages. Finally, they advanced the interest of administrative simplicity, that it was simply too hard, too much of a burden for the federal government to be figuring out what to do with these gay married people in the context of other married people, and that this was just too much of a burden for the federal government. And as my friend Mary Bonato has said, the federal government is not a mom-and-pop operation. We think they could probably handle this. And if anything, what the record showed is the very real burden created for our states on having to, in our books, in our mind, treat these people differently from the way we treat all other married people. So at the end, what we're really left with is animus. And I believe that DOMA is the most discriminatory law on our books today. I believe it's the government's official stamp of disapproval of gay people. And I believe that our Supreme Court has made clear in cases like Romer that animus can never form the basis of a law. If you remember Romer, that was the case where the Supreme Court struck down an amendment to Colorado's Constitution that was going to deny wholesale equal treatment to gays and lesbians. And I believe that DOMA, like Amendment 2 in Romer, identifies people by a single trait and then denies them protection across the board. DOMA is unprecedented, it's unusual, and it's a wholesale denial of recognition. It causes harm to our families, it causes harm to our state, and it strikes at the heart of basic principles of an even-handed application of the law and respect and worth of a sovereign's determination. We're obviously very happy with the district court's decision. The case is now, which found in our favor on all counts, so we prevailed on our 10th Amendment theory and we prevailed on our spending clause, and the district court judge ruled that DOMA is unconstitutional in Massachusetts. Now, that ruling has been stayed, okay, because it was then appealed by the federal government, and the appeal is now on before the First Circuit. Some of you may have caught a little over a month ago now that President Obama and Attorney General Holder have announced that they too have concluded that DOMA cannot withstand heightened scrutiny, and that discrimination on the basis of sexual orientation is wrong. While they've said they're not going to, the Department of Justice isn't going to defend DOMA in cases going forward, they are going to continue to defend in our case because our case was decided on a rational basis. So they're going to stay in for that. However, because they've made that announcement, there is a federal law that permits Congress to now intervene or attempt to participate in the proceeding. Congress is now in the process of determining its course of action, but we expect that we'll see Congress looking to participate in our First Circuit appeal. So the briefing schedule is currently on hold while that's sorted out. But in closing, I just want to say that I think it's very important that we as a state brought this case and that we attempted to put a face on the issue. No matter how all of this sorts out, for us it was very important that we took the opportunity to educate the public, both within Massachusetts and outside of Massachusetts, with the very real consequences, day in and day out consequences of a law like DOMA. And as a lawyer, and for aspiring lawyers, it was very satisfying to me to see the basic principles enshrined in our Constitution over 200 years ago, made real in the concepts discussed and debated through the course of this litigation. It gives me great hope about the profession that I chose, and I do thank you for the opportunity to speak with you a little bit today.
Thank you, Maura. Just so you know, we're now going to transition into the second part of our program. I'm going to ask my colleagues here to join Maura on the panel. If you have to leave, this would be a good time to do it, but we hope you won't. We hope you'll stay with us. Let me introduce the members of the panel who will be taking up the discussion from where Maura's presentation left off. You've already met Maura. To her left is Professor Dawn Johnson. Dawn Johnson joined the IU Law faculty in 1998 following a distinguished career in Washington, where she served in the Justice Department under President Bill Clinton, including as acting Assistant Attorney General in charge of the Office of Legal Counsel. Prior to that, she was legal director of the National Abortion and Reproductive Rights Action League. She also serves on the National Board of the American Constitution Society for Law and Policy. Next to Dawn is Thomas Fisher. Tom Fisher is the Solicitor General of Indiana, responsible for the state's docket in the U.S. Supreme Court, where he has argued 3 cases, as well as representation of the state in other federal and state courts of appeal. He has defended Indiana's statute precluding same-sex marriage before the Indiana Court of Appeals and has served as lead or co-lead counsel on multi-state amicus briefs, including one filed in the Massachusetts case, defending traditional marriage or marital benefits laws in 3 federal circuit courts. Next to Tom is Professor Deborah Whitus. Deborah Whitus joined the Maura faculty in 2009 after teaching at Brooklyn Law School and serving as a staff attorney at Legal Momentum, formerly the Now Legal Defense and Education Fund. Her research interests include employment law, family law in the legislative process, and the significance of gender and gender stereotypes. She has written briefs and scholarly articles on same-sex marriage and won awards for her scholarship from the Association of American Law Schools and the Williams Institute at UCLA Law School. And next to Deborah is Brian Powell. Brian Powell is Rudy Professor of Sociology here at IU Bloomington. His research interests have focused on family sociology, sociology of education, gender and social psychology, and his work has been funded by the NSF, the American Educational Research Association, and the Spencer Foundation. His new book, Counted Out: Same-Sex Relations and Americans' Definitions of Family, has received attention from the New York Times, the Washington Post, CNN, and ABC News, among others. What I'm going to do is engage the panelists in some discussion on some issues that pick up where Maura left off, and then we will have room at the time at the end of the program for you to ask your questions of Maura or the panelists as well. I want to start with Professor Johnson, picking up on the point Maura made at the end of her talk that a little over a month ago, the Department of Justice made the very dramatic announcement that it would cease defending the Defense of Marriage Act in court, while at the same time essentially leaving the door open for the House of Representatives to come in and defend it in suits, at least suits where the established level of review was not rational basis. Dawn, you've written about this issue in a law review article titled Presidential Non-Enforcement of Constitutionally Objectionable Statutes. You've also been an official in the Department of Justice when it was faced with a similar question during the Clinton administration. What are the precedents for a decision like this? Are there formal standards for deciding when the executive branch will decline to defend an act of Congress, as it has done here?
Thanks, Steve. So I did advise the Clinton administration on these kinds of questions. It came up in actually many, or I'd say several, contexts, and one in particular that I'd like to talk about. And I'd say, there are memos and guidance and letters to Congress, but no official standards is the bottom line. My bottom line also is that this decision by President Obama is well within his authority, no question about that, well within past practice of how presidents have exercised that authority, and I think clearly the right thing for him to do, and I was very happy to see him make that decision. I'll add he would have had, I think, the authority to do the opposite and continue to defend the statute as well, but I think he clearly made the best choice here. First, I just want to clarify some confusion that's out there. The article that I wrote, and on occasion the way in which this arose when I was in the Clinton administration, was in a different context. It was in the context of a decision not to enforce a statute, not to comply with the law. And the strongest critics of President Obama's decision in this case have confused this issue. So Newt Gingrich and Glenn Beck, they have been, attacking President Obama, saying, falsely claiming, or to be maybe given the benefit of the doubt, mistakenly claiming that he was refusing to enforce or comply with the law. And Gingrich even said President Obama should be impeached for this. And that's just clearly not what's going on. We have had examples where presidents have refused to enforce laws, even in recent memory. When President Bush claimed the authority to not enforce the federal statute banning torture. And that does raise very important constitutional questions. But here, we are not faced with the same kind of constitutional threat to the rule of law question, because President Obama made clear that his administration would enforce DOMA. And what they were saying in the decision they made was that when they were before a court, and a court would be making a decision about the constitutionality, that President Obama's lawyers would tell the court what they thought to be the right view of the law and the right standard of review, rather than making any reasonable argument in defense of the statute. And so that does raise an important question of deviating from the typical practice, but it is not a constitutional dimension the way a decision not to enforce would be.
Dawn, can I ask you,
yes.
What is from your time in the Justice Department, what's the process that the President and the Attorney General and the lawyers in the Justice Department would go through to reach this decision? I mean, the
right.
statement from Attorney General Holder said the President himself has decided that the Defense of Marriage Act is unconstitutional. What's
yes.
that process like?
Yes, so that came up, as I said, several times, and most notably, I'll talk about one, and the process we followed there, which I would expect is very similar to the process here. And from what we can tell, in fact, what was the same process, given that the statement said the President personally had made this decision. So it came up in the context of the 1996 Defense Authorization Act, which directed President Clinton to discharge anyone in the military who tested HIV positive. And President Clinton personally was gravely disturbed by this and believed that his initial, reaction, both Clinton and Obama, constitutional law professors at one point in their lives, and he said, this has got to be unconstitutional. And this violates the rights of people in the military, firing them for no legitimate reason. There have been very offensive statements in the record by the sponsor of the provision and no serious debate. So he directed my office, the Office of Legal Counsel at the Department of Justice, to advise on whether he had to enforce or defend this, what were his options in the face of what he thought was an unconstitutional statute. And he also asked, do you think it's unconstitutional? What's your view of that? So we consulted extensively with the Department of Defense, the Joint Chiefs of Staff, the White House policy people, many meetings, within the government, met with outside advocacy groups, thorough review, and in the end, made our recommendation, and the President personally made the determination that he did not think it was constitutional and that it was one of those rare instances where it merited not complying with the typical practice of making any plausible argument in a court of law. So I think that reflects the right process, and as far as we can tell, that was followed here. I think it should be a decision made by the President personally after carefully considering both the specifics of the matter, and here, with DOMA, what is the standard of review for laws that discriminate on the basis of sexual orientation, I think clearly merits a deviation from that practice, but then also thinking about it in the context of what are the costs of deviating from the normal offering of any reasonable argument, and here too, I think, as in the HIV context, it was merited. I would say one last thing, and that is, I think it is important for, in these contexts, the President to say Congress should repeal the provision, because that is the preferred way of getting rid of an unconstitutional statute. In the context of the HIV provision, President Clinton worked with Congress and was successful in getting Congress to repeal the provision. Rather than Congress having to defend it itself, they repealed it before its effective date, and that was a great ending. In here, too, I think it would be appropriate to work with Congress to repeal this. But if that doesn't happen, perfectly appropriate for Congress to come in and defend it itself if it wants.
Great. Thank you. Tom, you work with the Attorney General to determine what legal position the state should take. Of Indiana, right. You work with the Attorney General of Indiana to determine what legal position the state should take in litigation that potentially affects Indiana's interests. Indiana has joined with 4 other states, Colorado, Michigan, South Carolina, and Utah, to file a brief opposing Massachusetts, opposing the argument that Maura has presented in this case. You argue that the 10th Amendment theory that Massachusetts relies on is flawed. Tell us just a little bit about that. Why is Massachusetts wrong on this issue? And how will Indiana be worse off if Massachusetts were to prevail in its case rather than the federal government?
Well, I think the starting point is that our office takes federalism issues very seriously. And in fact, my boss, the Attorney General, is in tune with a lot of concerns about 10th Amendment encroachment around the country. And in fact, we are part of the group that has filed a lawsuit in Florida challenging the Affordable Care Act. And we very much agree with the argument in that case that there is an encroachment on state interest. There is, in fact, a transgression of the spending authority when it comes to the expansion, the unprecedented expansion of Medicaid. So this is an area where we regularly, as we put it, in fact, in our amicus brief, sort of tend the boundaries between state and federal authority. Now, one thing that we are generally concerned about is that our perhaps somewhat more typical position, that is to say, to stand up and be counted when we see an encroachment by Congress, rather than risk that become something that is seen as a knee-jerk reaction, that it needs to be part of a larger understanding, a coherent understanding of where the proper delineation of federal and state authority is. And our decision to get into the middle of the Massachusetts case came upon reviewing the district court decision as opposed to the complaint or anything else in the case, and coming to the conclusion that this seemed to be the sort of thing that if it were carried out, if it were followed to its logical end, would ultimately discredit the arguments that we're making in the Obamacare case, and we might make in other cases when we're concerned about the limits on federal authority. So in our view, the interest of the state in part was to come in and talk about how a proper understanding of federalism, proper understanding of the 10th Amendment requires us to break down the arguments in the particular case. In other words, not, as we put it in the brief, not all 10th Amendment arguments are created equal. And here, what we've got is not, in our view, an effort to usurp state authority over bestowing the status of marriage, but in fact, an effort to define the limits of federal programs. And what I think is important to bear in mind is we went into this trying to be very careful about not going too far. We didn't want to suggest, and we don't suggest in our brief, that there can be absolutely no 10th Amendment objection in this context. We were concerned mostly with the district court's use of First Circuit precedent, its decision to use what were Commerce Clause cases for what we thought of was essentially a spending clause case. And we disclaimed that we were weighing in on a whole host of broader issues. We did say that we rejected the equal protection theory, but that we were not going to go out of our way in this circumstance to map out our equal protection argument because there were so many others in the case already doing that. So that's basically the origin of the decision to become involved in the Massachusetts case. There's I think a desire to make sure that when we go forward and offer 10th Amendment arguments as to the unconstitutionality of federal laws, they are understood in a broader context that has a sort of more coherent and broader understanding of that proper delineation between federal and state laws, areas of authority, mind you.
Great. Deborah, I want to ask you, Maura made reference to a companion case that's now been joined, another case challenging DOMA under the Equal Protection Clause brought by a number of same-sex couples in Massachusetts. Tell us more about that case, and how does the theory of that case and the impact of that case potentially differ from the direct case that Massachusetts is bringing to protect its state interests?
Sure. So as Maura mentioned, there is a case brought on behalf of 7 same-sex married couples and then 3 widows or widowers who had been married to a same-sex partner and being represented by the Gay and Lesbian Advocates and Defenders, GLAAD, which is the same organization that brought the Goodrich case. And that sort of discussions around that case predated Massachusetts bringing its own case. And that case really is a classic Equal Protection Clause claim brought by these couples, saying that the federal government just doesn't have legitimate justification for treating their marriages differently from all other marriages. And I think that case complements the Massachusetts case well in many respects. First, it's just helpful to have a face. And I think that the Massachusetts in Maura's presentation does an excellent job of showing the state interest, and the example, say, from the Veterans Cemetery is a real sort of human cost expressed through the Massachusetts case. But it's helpful when litigating to have couples that you can put forward who can tell their stories and can talk about how, my partner works for the federal government, I would like to get health insurance, I can't, or I need to pay extra on my taxes, and really bring home the real costs of that. My partner died, I have to pay, taxes that I wouldn't if we were recognized as married. I can't have tax benefits that I would have if we were recognized as married. And so the couples in the case can bring forward and show the real costs of that in a way that's different from what the state can do. It's also, in some sense, a much easier Equal Protection Clause case than what's happened in other states that have tried to establish the threshold issue of whether or not same-sex couples have a right to marry. So the the Goodrich case, the first case that Maura talked about that established that in Massachusetts same-sex couples have a right to marry, and similar cases that have happened in Iowa, in California, in several other states, same-sex couples have had to go in and show that they are functionally similar to different sex married couples, and that there's no legitimate basis for state laws that had said, same-sex couples can't marry. And that is not an impossible argument, as we saw in Massachusetts, but it's in some sense a difficult argument, and it's obviously bucking against tradition in the sense that states have long limited marriage to different sex couples. The couples in this case have what I think is actually a much easier Equal Protection Clause argument, which is just going in and saying, federal government, you have no legitimate basis for saying that our marriage is different from any other marriage. We are married under state law. The state has already made the functional assessment that matters, which is that we meet the qualifications for marriage, and there's no legitimate basis for then making a distinction between us and any other married couples. And so I think it's been really interesting as it progresses to see that play out, because if you look at the district court decision in Gill, the court says that very clearly. It says, this is a line that's already been drawn. The federal government has always relied on state marriage rules, and here it's just doing, we think it needs to do exactly what it's always done, which is, I think, a much easier Equal Protection Clause argument. And the last thing I think that's interesting is that even before the Department of Justice decided that it would no longer defend these provisions of DOMA, or at least argue that heightened scrutiny didn't apply, there were already ways in which the defense was being shaped by the administration. So the rationales that Maura talked about that Congress relied on in passing the 1996 law, that is that preserving different sex marriage promotes responsible procreation by different sex couples by encouraging them to form stable bonds, and that preserves the traditional definition of marriage. The Obama administration itself, in defending this case below, said we're not going to rely on those justifications. And that's an internal discussion that had to happen as to whether or not those justifications were plausible enough for the government to rely on. And I will say that there are many states that have relied on precisely those justifications in upholding state different sex marriage laws. So Supreme Court decisions in Washington State and the highest court in New York looked at challenges and said, you know what, that responsible procreation argument is enough to pass rational basis review. And so I think that it's really interesting to note that here, even before the Obama administration decided more generally it wouldn't defend it, that it was really assessing and carefully weighing what are the justifications that we think we can put forward as justifying this law, and how do we do that assessment?
And before I come to Brian, I want to ask Maura quickly, in case it was unclear, I mean, both the same-sex couples in the Gill case that Deborah talked about and the state of Massachusetts won their cases in federal district court last August, I believe it was. They've both been consolidated for appeal. Has this been an easy relationship? Are there times when there are tensions in the arguments that, you know, the Massachusetts needs to say one thing or make one argument or highlight one fact, and, you know, the same-sex couples in the other case have some different, a different interest? What's this relationship been like to work with the state working together hand in hand, really, with a group of couples making different arguments but aiming at invalidating the same law?
Well, it's been a very healthy discussion and rigorous discussion, and I think that exchange really sharpened the arguments in both of our cases and how we approach things. Of course, we're lawyers, so we're not going to naturally at times going to have differences of opinions or perspectives on how to approach an issue. But we believed that in this instance, 1 + 1 was stronger than 2. And as Deb said, we think that the cases are very complementary, and it has been, I think each case has helped the other in showing this law for what it really is.
Great. Brian, your research, including a new book last year that's received considerable attention in the media, focuses on the changing attitudes that Americans have toward families that are headed by same-sex couples. What are some of the most significant findings, some of the most significant changes over time that you have documented, and is there anything that most surprised you in your findings?
Well, I'll start with the assumption that's out there. And the assumption is, you actually see the assumption in one quote that was as frequently mentioned. The first time I heard it was after the last election, when 3 judges in Iowa were voted out because they basically determined that the prohibition against same-sex marriage was unconstitutional. When they were thrown out, one of the people who was really organizing this campaign said, "It's we the people, not we the courts." Now, setting aside the issue that we should always rely upon public opinion, because as Maura pointed out, if that were the case, we still may not be allowing interracial marriage in the United States today. It is interesting to see that if we really want to use the standard "we the people," we may end up with a very different position than what the advocates of heterosexual marriage only would want. I'll give you just a few quick findings that we found. And basically, we're basing this on interviews that we collected, national interviews that we collected in 2003, 2006, and 2010. The first one is that Americans are continually moving away from a traditional definition of family. What I mean by traditional definition of family, people who say a family is, in effect, as family is, as one state legislator said just a few weeks ago, a man and a woman having children. That's the definition of family, which, by the way, would mean if you're married, you don't have children, you're not a family either. But in 2003, almost half the people had what we called an exclusionist definition of family, a more traditional closed definition of family. By 2010, that figure has gone down to approximately 1/3. In other words, what that means is at this point, around 2/3 of Americans believe that at least some types of same-sex couples count as family. The second point, and this is one I was actually a little surprised by, has been the change in people's views about same-sex marriage. What we find is that people's definitions of family map on really nicely with whether or not they believe same-sex couples should be allowed to get married. But we didn't see between 2003 and 2006 that much of a change in people's views about same-sex marriage. We saw more than an incremental change between 2006 and 2010, though. In fact, when I looked at the data, the patterns indicated that over half of Americans who we interviewed were supportive of same-sex marriage. I didn't believe the data. I must admit, I didn't believe the data. But I began to believe the data when a series of other national surveys came out, concluding pretty much the same thing, that more people today support same-sex marriage than oppose it. There still is a group that's still not sure what to do with it. But the idea that it's so clear we, the people, are opposed to same-sex marriage is not supported by the data that in the surveys. Now, of course, the third point, though, is, of course, what public opinion and what people think, or we, the people, is not the same thing as we, the voters. And that's where there's a big distinction. And the biggest distinction here is generational differences in people's views regarding same-sex couples and same-sex marriage. If only those people under the age of 50 voted today, we would overwhelmingly be having same-sex marriage. And if it's people over the age of 65, we're not going to be seeing it. And as we know, people over 65 have a much greater rate of voting than people who are younger.
I have a friend who teaches political science at Hunter College who said basically on this issue, the Grim Reaper delivers about 1% of the vote a year.
One last point, and it's from the surveys we conducted in 2010, there's some evidence about what might happen if in effect the court case, if in fact the DOMA appeal is successful. We asked people several questions regarding whether or not they would consider a same-sex couple who's married a family. And so basically what we're able to do is distinguish between those people who say a same-sex couple who's not married is not a family, but a same-sex couple who is married is a family. The figure doubles. Now, what's really interesting, though, is we also ask the question, what happens if they're married and they move to a state where they're not legally married? Now, I know that's not exactly the same case that you're dealing with, but it speaks to the same basic topic. There almost the same percentage of people said, yeah, they're still a family. In other words, Americans buy into the idea of law, and if people are viewed as legally married in one place, they will be seen as legally married, at least by the American public, elsewhere.
Maura, let me ask you, what use is data like the kind of findings that Brian has talked about, changes in public opinion, what use of that do you make in your case? Does that inform your arguments to the court, or is that helpful, but it's really not relevant to the kinds of legal arguments that you need to make?
It's very relevant and critical, and we used some of that very data in our case. As Deb said, Justice did not defend on the purported bases for DOMA at the time of its enactment. Okay, it disavowed the majority of those, but we knew that didn't mean the court couldn't take cognizance of those interests, or that we wouldn't see amici or others looking to advance those interests as arguments in support of DOMA. So to address that and head that off, we pled the case and briefed the case and submitted the record in the case that addressed all those issues, including issues around procreation and child rearing. We had testimony from psychologists on this issue, including Michael Grossberg. I don't know if he's here, but terrific. Thank you so much. An outstanding expert affidavit was submitted on behalf of our case to debunk some of the notions and myths around the effect that same-sex marriage has on children and families.
Tom, you have litigated a case here in Indiana defending the state's definition of marriage. I don't know that you have any inside information or if you talk to John Boehner on a regular basis, but I'm wondering, how do you anticipate now that the House of Representatives, which passed this law, will be taking up the defense of the law? What arguments do you anticipate the House will make to defend DOMA? How will they shape the case in defense of this law? And then I want to ask Dawn, after you've talked about that, to talk about how much weight does it have to a judge when the administration comes in and says, we think a heightened standard of review ought to apply to discrimination against gays and lesbians. But do you see the road, Tom, ahead for the House in representing DOMA as a difficult one, or one that under the prevailing legal standards, should be a fair fight?
Well, I don't have any inside information. I think John Boehner won't take my calls this week. He's busy. So I think there might be, I can conceive that there might be a difference, and I'm just hypothesizing and speculating, that the members of Congress, if they come into the Massachusetts case, they may perceive the posture there to be different from a case that's a new case that gets filed. Principally because the Department of Justice has already filed a brief, they've already laid out their arguments. It's not to say there wouldn't be some procedural means for augmenting those, and I think they would be justified in doing so, but I'm just imagining that it'll at least cross their minds that, well, this table's been set, maybe we ought to wait for the next case or the next level to bring forth other rationales. But I would imagine that ultimately the responsible procreation theory is going to be front and center. DOMA is not at the end of the day going to be left with the sort of status quo preservation kinds of arguments that the Department of Justice has offered to this point.
Okay, because one of the rationales when Congress passed DOMA in 1996 was preserving the traditional understanding of marriage and setting forth Congress's view that children were optimally raised in same-sex households. And so that is what the House will likely rest on as its rationale for defense.
Yeah, I think ultimately that they'll have to, and I don't think that there's going to be any hesitation on the part of the House as it's currently composed anyway, to do that. Yeah, so it's just a question of sort of procedurally what vehicle, all that kind of stuff.
Mm-hmm, yeah. Dawn, is this significant to a judge when well, let me ask this. So first-year law students in your constitutional law class learned that in Marbury versus Madison, Chief Justice John Marshall said it is emphatically the province and duty of the judiciary to say what the law is. Should the president or the Congress get to have their own independent interpretations of what the Constitution requires? The administration is going to go in and say heightened scrutiny, stronger skepticism toward discrimination against gays and lesbians is what the Constitution requires. Does that carry more weight when the president does that than when a private plaintiff comes in and makes that argument to a judge?
I think it absolutely does, and it should, and it has. Now, we are going to have Congress, the other branch there, saying they disagree, so we'll have both branches arguing about that. I think it should carry significant weight for two reasons. One is the administration has made the extraordinary determination that this is of historic importance. This is so momentous a question, and just talking about the standard review question for sexual orientation discrimination, that the Department of Justice and the President have deviated from this strong practice, and that rarely happens, and this merits it. So I think that will be taken seriously. I also think that the quality of the brief and the actual arguments being made by the court will be very persuasive, because up until now, the Justice Department has had its hands tied. It's had to come up with the plausible arguments for something that really was difficult to defend. And now they will be able to argue under heightened scrutiny what they think is actually true. And that will be, I think, very, very compelling to the court. Also, at the same time, they're being careful. They're going to be saying, if the standard is rational basis review, then we can come up with, create plausible, non-frivolous arguments. So it will look like and will be a very carefully thought out, precise argument, that it's only when we recognize that discrimination on the basis of sexual orientation merits heightened scrutiny and protection from the courts that it is unconstitutional. Finally, on the federalism questions, 10th Amendment and Spending Clause, the Department of Justice will still be arguing that Congress has broad authority, which, and I'm skeptical of the federalism arguments myself. I think clearly DOMA is unconstitutional under equal protection, but you'll have the Department of Justice making subtle and I think careful substantive arguments in its briefs.
So just so we understand, the Obama administration will defend the Massachusetts case because the standard of review there is lower, but it will not defend, and the House will come in and defend the Gill case that Deborah talked about. Is that basically correct?
No, they're defending Gill as well.
They are defending Gill as well.
Right, because both Gill and the Commonwealth's case were decided under rational bases, and so they're going to rest on the brief filed already in our case. We and Gill plaintiffs were 5 days away from filing our appellate brief when the president made the announcement, and the First Circuit then vacated the briefing schedule. But justice is still in the case. So just
so we're clear, then, the administration's decision not to defend DOMA is really applicable to some new cases that have been filed elsewhere in the country, one in New York, I believe, and one in Connecticut, where the standard of review for discrimination on the basis of sexual orientation is not established.
Right. And in the First Circuit, some would argue it was established in the Cook decision, the failed challenge to Don't Ask, Don't Tell that I was a part of. But following the announcement of Judge Toro in our cases in July of the summer, there were 2 suits filed, one by GLAAD in Connecticut and one by the ACLU in New York, follow-on DOMA challenges. And there, it's an open field.
It is really the new filing of those cases rather than the continuation of your case that prompted the Department of Justice to make this decision and announce that it believes heightened scrutiny is appropriate.
I can't speak to what prompted them to make the decision. Yeah. It certainly provided an opportunity because they were for the first time going to have to take a position on the level of scrutiny to accord sexual orientation. However, they had the benefit of at least one court out there ruling that this kind of discrimination was unconstitutional.
Deborah, let me ask you, picking up on Brian's work on changing attitudes toward families, some of your scholarship has focused on gender stereotypes that are embedded in the decisions of some of the courts that have considered these same-sex marriage suits. What are those stereotypes and why are they problematic? What work are they doing, and are they appropriately doing that work in these marriage decisions?
Sure. You don't see them all that clearly, I think, in the Massachusetts and the Gill case, but if you look at some of the other challenges in other states, the sort of initial challenge, that is, the seeking a right to marry, the defenses raised, and this is a place too where I think you see a really interesting distinction between the kind of arguments that you see states making as the actual defendant in these cases, and then you see amici coming in and making in their briefs, and sometimes being picked up then in the court decisions. So New York, for example, its highest court, which about 4 or 5 years ago upheld its different sex marriage law, said that the justifications for this were that it was common sense that kids do best with a mom and a dad in the house, which is kind of implicitly that mothers and fathers, by virtue of their sex, play distinct and different roles in the family. And then this responsible procreation idea, which is essentially that without the bonds of marriage, irresponsible men will impregnate women and will not stay around to support women and their children. That's sort of the fullest explication of it, and that marriage and the stability of marriage is necessary to avoid that. And that, too, is kind of deeply embedded in stereotypes about male and female roles and the vulnerability of women and the need for male support. And here, usually, if you look at the state briefs in these cases, they don't spell out these stereotypes all that clearly. Excuse me, I'm getting over being sick. But if you look at some of the amicus briefs filed, they're quite clear. So, for example, on the male and female role models, I did a paper that looked at several of these briefs, and you would see things like, well, fathers are necessary for teaching risk-taking, and mothers are necessary for teaching nurturing, and those are irreplaceable. And so those arguments are made very clearly. And so I think that's sort of deeply embedded in these cases as sort of larger issues of sex stereotypes and a whole line of equal protection doctrine under sex discrimination doctrine, as opposed to sexual orientation discrimination, but a line of sex discrimination cases that says that government laws can't rely on overbroad generalizations and stereotypes about the different sexes.
Brian, constitutional lawyers worry about what's called the counter-majoritarian difficulty, the idea that it's democratically problematic for courts to get too far out ahead of public opinion and to overturn the will of political majorities. From your knowledge of how public attitudes are moving, are gays and lesbians and their advocates better off working through the normal political process to achieve marriage rights rather than asking courts to do it?
I'm neither a legal scholar nor am I a social movement scholar here. But first thing is, your question assumes that that the public opinion is really far behind. And what our research is suggesting is that public opinion really, we are probably at the tipping point. In fact, we may be beyond the tipping point. So the idea that courts, that we should be careful about courts, I worry what's going to happen is court decisions and legislative decisions right now may ultimately be reflecting the position that is right now seems to be the emerging minority. Even if we buy the idea that right now it's 50-50, we can, I would bet anybody in this room that 10 years from now, support for same-sex marriage is going to be so much higher. So the idea that courts should be careful and wait, and then have legislators pass things that 10 years from now will be absolutely contrary to public opinion doesn't make much sense to me.
Tom, Indiana has advocated, I think, a different view of that in another brief that the state has filed in the Perry litigation. So there is a federal court challenge right now on the West Coast to California's refusal to allow same-sex couples to marry. Indiana has joined with a number of states to file an amicus brief in that case, making arguments that this is someplace where the federal courts ought to tread carefully and ought to respect the sovereignty of the states. Do you have a different view than Brian? I mean, how should we be thinking about the legitimacy of courts making these decisions rather than legislators and voters from the position that Indiana has taken in these cases?
I think courts should rule based on the law and not based on public opinion. He may well be right about where public opinion is headed, but through the judiciary is no way to do it. So that's what we're advocating in the Perry case. It's a matter of, gosh, when we look at the what the Constitution protects, is it really a matter for federal courts to go in and redefine marriage? Is the way it's been understood, since the beginning of the Republic and before. So it's not an issue of public opinion there.
Okay. All right. We have some time for questions, and so you have been very patient, and hopefully this has been interesting. We want to give you an opportunity to direct some questions to our panelists. Please keep them concise, no speeches. We'd like specific questions, and I may need to repeat your question or summarize it so people watching the webcast now or later will be able to hear them as well. So let me start in the back. The first question I saw, and then up here, the gentleman in the front.
This is, I'm sorry, Maura, your last name?
Healey.
Miss Healey. You argued, or the argument that you made is that based on 10th Amendment and federalism, you have an argument against DOMA, and it's resting on the premise that individual states have the power, should have the sole power to define marriage. And I know that you said earlier you aren't arguing the other section of DOMA that qualifies the full faith and credit clause of the Constitution. Does that mean then that based on your 10th Amendment and federalism arguments that you would continue to support that section of DOMA, which wouldn't foist on certain states that have defined marriage between only a man and a woman, that they would be able to continue that definition?
Okay. So let me just repeat quickly for the webcast audience. The question is, Massachusetts is challenging one provision of DOMA, the denial of federal recognition to marriage. Has it taken a position, or does this challenge involve a challenge to the full faith and credit provision of DOMA, which says if a state like Indiana or Michigan or other states that don't have same-sex marriage don't want to recognize a Massachusetts marriage, when a couple moves from one state to another, they don't have to. Maura?
Well, they're legally distinct issues. I think Section 2 is unconstitutional, but the Commonwealth has not taken a position on Section 2. But on Section 3, we do think states have the right. Of course, states are at all times bounded by the United States Constitution. So when we look at Perry, a case in which the Commonwealth of Massachusetts also submitted an amicus brief, okay, that's the right to marry case. Remember, our DOMA challenge is not about a right to marry. These people are already married, and it's about distinctions between married persons. It's why we believe we can, Perry was correctly decided, and we support that decision. I mean, it's akin to what happened with Loving in 1967. It's precisely why you need courts at times, and you cannot leave certain decisions to the public.
There's a question here in the front.
Yes, Brian, does the data that you're referring to, does it deal only with attitudes toward same-sex marriage, or does it also cover the spectrum, including people who perhaps are opposed to same-sex marriage, but who would be in favor of, or at least would not object to, civil unions and other arrangements?
Yeah, actually we do ask questions regarding civil unions. And what we find is if you ask the question, marriage, civil unions, or neither, it's a little over 40%, 44% marriage, 26% civil unions, and 30% none of them. Well, what's interesting about this is we also then asked, in thinking about your answer, what do you mean by civil unions? And what we found is that many, many people who were in favor of civil unions actually didn't know what civil unions were. And many people who were opposed, vehemently opposed to civil unions, didn't know what civil unions would be. But when they did define it and they were incorrect, the most common mistake they made was a civil union is getting married at the justice of the peace. In other words, what this means is that there are many people out there who are, say they are opposed to same-sex marriage and opposed and in favor of civil unions. Actually, they are in favor of same-sex marriage. And I think this really speaks to one of the big issues that we kept on finding within our interviews, and that is how the American public often confounds the religious ceremony and the religious component that often you see in marriage with the civil or legal component of it.
Other question? Yes.
Yeah, first, I'd like to say that I don't have a legal background. I'm retired from another profession. In the last year, there was a case somewhere, and I don't remember the specifics, but it was an abortion case. And I think it was the judge hearing this case was a practicing Catholic. And somebody in his parish, somebody in the church, elders of his parish, like the parish priest or the bishop or whoever, said that if the judge made a certain ruling, he would start the process of excommunication for the judge. So my question then is, right now on the Supreme Court, using an example, we have several Catholics and several Jews. Actually, there are no Protestants on the Supreme Court right now, as I understand it. And practicing Catholics, the church has a very strong opinion on certain social issues, such as homosexuality. And actually, Orthodox Jews have a similar opinion. But so when these kind of cases come to the higher courts, does a judge who's a practicing in any religion that opposes, these kind of social issues, does he or she have to recuse herself?
They all have to recuse.
Anybody want to try that one?
No.
I agree. Clearly not, and that's not the practice. On abortion in particular, I think the doctrine's clear that it's not viewed as a question of religion, an imposition of religion for the government to restrict abortion, for whatever it's worth. That's the doctrine, and judges. I'm not familiar with that particular case. I mean, I've heard of other contexts with elected officials being threatened with excommunication, but I don't know of a judge.
I'm in the middle of reading a very interesting biography of Justice Brennan, who dealt with this issue as tensions between his advocacy, his role on the court, his decisions on the court, and as a Catholic and his Catholic faith. So that might be something you want to look at.
Can I just add one last thing? I think it's also really important to point out that all of these cases are about state recognition of marriages or federal recognitions of marriages. There's no state, none of the ones that recognize same-sex marriage, that requires religious entities within those states that are doctrinally opposed to same-sex marriage to perform those marriages. So, you know, the Catholic Church is not in Massachusetts required to perform marriages, and neither are Orthodox Jews. And I think that that's a distinction that's lost a lot, and that's very, very important.
I want to pick up quickly on the reference to the Supreme Court and ask Tom, because Tom has argued at the Supreme Court, has represented the state of Indiana in 3 arguments at the Supreme Court. Do you think this issue is going to get to the Supreme Court sooner or later? And in what form will that happen? Will the Gill and Massachusetts cases make it there? Will the Perry case make it there? Will one make it before the other? How is this going to reach the Supreme Court? Is that inevitable?
Well, I think the issue of same-sex marriage will get there. Now, whether it comes in a DOMA challenge, though, I think depends in large part on whether there's a court of appeals that invalidates it. If that happens, bam, it's there. If not, I would be surprised, absent a circuit conflict, that the court would want to go out of its way to take one of those cases just because people think it's important. Just, you know, the court tends to be somewhat risk-averse in these things. But it's inevitable that this issue, this same-sex marriage issue, through some vehicle, is going to wind up there. I mean, Perry right now is sort of on this sidetrack of, gosh, do the proponents of Proposition 8 have standing to continue the thing on appeal? So it's entirely possible that that won't be the case because maybe the Supreme Court of California will will say no, they don't have standing in our courts, et cetera, et cetera, et cetera. So it may be some other vehicle, but boy, I just don't see much hope for the Supreme Court to be able to avoid it.
Yes.
Yeah. So if it's decided that states have the power to define marriage without any interference from the federal government, I can see that as a good thing for states that already have same-sex marriage legalized. But it also kind of scares me for living in states like Indiana where same-sex marriage is not legal. And, you know, coming from my point of view, I have no law background at all, but I kind of wish there was, you know, a federal definition that marriage could be between a man and a woman or between two people of the same sex. So can you kind of talk on that issue?
Do you have one particular person who you think would be good for that question?
Maura.
Yeah, well, it's a great question, and you know, it's a subject of a lot of sort of discussion. The case you're looking for is the Perry case, the case that we've been talking about out in California, which was the challenge to the California ban on marriage for same-sex couples. And if the court has decided that the trial court has decided that and ruled that ban unconstitutional, in the same way the Supreme Court ruled the ban on interracial marriages back in 1967 unconstitutional. And the result was that no state could, in its laws, right, setting up its eligibility requirements, prevent interracial couples from marrying. And that's what Perry would result in. No state could, in configuring its rules, prevent gay and lesbian couples from marrying. Okay? So I think that's how you would get there, right? So you don't need a state definition out of Congress if there's a determination by the court that it's unconstitutional for a state to act that way. That's the right. That's the difference between a right to marry case and what our case is about, which is just when dealing and looking at the people who are already married, what's the relationship with the federal government? How should they be treating these people?
Yeah, I just want to say I think your instincts are correct, though, to be concerned about, and this is why I'm skeptical of the federalism arguments, to be concerned about courts imposing limits on Congress's ability to legislate. And it would be something that the Supreme Court has not done to Congress's spending power. Congress exercises its spending power, you know, for a whole range of wonderful progressive programs. And if the court is able to impose this kind of limit on a substantive area and say this area is beyond your reach, that is going to have implications for a whole range of issues. So that, I'm sure you're very aware of that and have thought about that a lot. But that is what would concern me about this precedent continuing.
There's a question back there. Oh, in the red, yeah.
My question is for Mr. Fisher. I wasn't really able to follow your explanation of the state's position on the 10th Amendment issue.
Sure.
How does arguing that the federal government doesn't encroach on states with respect to marriage help your argument that the federal government does encroach on states with respect to health care?
I think it's a matter of staking out a credible and coherent approach to the 10th Amendment that when we take it to places like Florida and perhaps other situations where we're challenging federal authority, we're not seen simply as reflexively opposing federal authority in all circumstances. I think the Attorney General that I work for is concerned not simply about throwing around a term like states' rights. He's concerned about understanding federalism. He's concerned about understanding that there is a proper delineation of authority between the federal and state government. And so the concern has become that as we look at what the district court did in Massachusetts, this starts to look a little bit like something that plays into the hands of those that we face and say, well, look, this is just the states, crying wolf again over federal encroachment. So it's part of a larger effort to have a sustained litigation position that is coherent and credible.
Can I just add something to that? Massachusetts filed an amicus in the same healthcare challenge. It is the position of Massachusetts that healthcare is an area where there is a federal interest, a long-standing federal interest. When you talk about Medicare, Medicaid, and the effect on interstate commerce. So, just so you know, like as Attorney General, how we look at this issue of federalism, because we have obvious concerns about it too. In our view, healthcare is an area where there's a clear nexus with interstate commerce, and so we actually filed in support of the legislation. Whereas when it came to DOMA, we challenged it because, in our mind, the issue of the definition and regulation of marriage is something that narrowly falls within a state's prerogative. So I think we're, as Attorney Generals, concerned about these federalism issues, but obviously it just depends on your prism.
And when you come to law school, they say they teach you how to think like a lawyer. And it's these sorts of analogizing and distinguishing that's really the heart of what it means to think like a lawyer. The dean wanted to jump in.
I just wanted to follow up on those two comments because I think for the audience, one thing that might be interesting to think about is the contrast to what we've been hearing to Brian Powell's point earlier that the usual comment around the courts being involved in politically controversial cases is we the people, not the courts. What we're hearing on this panel is the assertion of two different states that they have standing, they have injuries caused by federal legislation. And that's a politically interesting and complicated claim. And raises a lot of dynamics and complicated political dynamics about the ways in which states, as opposed to the individuals Professor Whitus was talking about, should be involved in challenging federal legislation. As we go forward, I think these kinds of challenges from states are worth sustained attention, because they do raise different kinds of questions about how states and the federal government form allegiances with their citizens and what states should be doing in one way or another in the courts to invalidate the act of a different sovereign, when they should have the right to do that. And I guess I did make a speech.
You're the dean. This is your place. You're allowed. So I think we have time for one or two more questions. Kyle.
I have a question for Mr. Fisher. If the concern with regard to Indiana's amicus briefs is to maintain the appearance of consistency, why not simply take no position on the marriage cases and devote all the legal energy to Obamacare challenge?
I think considered judgment of the Attorney General is that in the long run, it is beneficial to the state's legal position nationally, whether it's in Obamacare or in other challenges, that we have staked out a position that does have a sense of limits about it, that it does have a direct tie-in to a very specific theory and understanding of the 10th Amendment, and that we establish that, when we can.
One final question. Well, let's do two. I saw this gentleman, and then we have a student back there. If you could make it quick, please.
Yeah, real quick. I'm just a little confused about Loving versus Virginia. I'm a layperson, by the way. Loving versus Virginia versus what's going on with gay marriage now. I think I know the answer. Once this reaches the Supreme Court, it will have the same status, whether it's decided as Loving versus Virginia. Then it will have that status, as opposed to using it as an example now.
Oh, I didn't mean to confuse issues. Well, we have two wonderful con law professors here.
I think the question is just if the Supreme Court, in, for example, the Perry case, would be more likely in the Perry case says that same-sex marriage, the rights of gays and lesbians to marry is protected under the Equal Protection Clause. The Supreme Court rules that, then that case would have the same status, historic importance as Loving versus Virginia did for interracial marriages, which is...
The 10th Amendment versus...
Okay, then I'm not sure. The 10th Amendment...
The Loving versus Virginia, they decided miscegenation as
right.
legalized by Virginia, what didn't count, but it was on a particular people, but the Supreme Court said, 10th Amendment, no, you can't do that, as opposed to the gay marriage. Will that have the same legal status once in conjunction with the 10th Amendment?
So Loving was an equal protection case, but I think the confusion is that I think we would agree on this, I think everyone would agree on this, that if the Supreme Court says the Equal Protection Clause protects the rights of gays and lesbians to marry just like it does the rights of African Americans and whites to marry, then the 10th Amendment argument goes away. I mean, then once there's an individual right established, then Massachusetts would not be arguing. No. There can't be a national standard imposed on Massachusetts, right? I mean, then clearly their position would be the individual right trumps.
Yeah, and I want to be absolutely clear about that, as I said, we as a state are always bound and have to live within the limits of the U.S. Constitution. So if someday, as the Supreme Court told Virginia back in '67, you cannot ban blacks and whites from marrying.
Right.
Okay? If that happens in California and the court says you cannot ban gays and lesbians from marrying, California and every other state in the country has to live by that. Okay? And I go home. We've done. We don't need that. Okay? Yeah, so
The case that could potentially do that is the Perry case that you've heard reference to in California. One final question. We have a student in the back.
So what I find maybe a little frustrating about the federalism arguments is people keep making reference to a principle that's driving a position on whether or not this should be an issue regulated by the state. I'm missing that. I feel like people argue about history, which is fine. Is there something beyond that? Because I find it honestly kind of obscure. Like, does anybody say, and the state really should be responsible for this because some sort of, people have adverted to theory and things like this. I'm not sure.
So the question is about sort of historical...
No, it's about something aside from historical. I wonder if there's, because the historical record should be relatively uncontested. I'm wondering if there's a principle or a theory that someone can articulate with some specificity about why we're taking the positions we're taking with substantive history.
Why the substantive area of family law is for the states only.
Deborah, you teach family law. Do you want to chime in on that?
Well, the federal courts have long basically stayed away from family law and said that there's no federal jurisdiction over domestic relations, which is sort of the old name for family law. And marriage has long been substantively regulated by the states, with the federal government just using whatever the state definition of marriage is for, as Maura mentioned, the 1,000 whatever places where federal benefits in some way use marriage rules. But different states have very different rules on, say, who can marry. So there are some states where first cousins still can marry. There are other states where they can't, and that's long been protected as a core basis of state sovereignty, and that states can make those kinds of determinations. So I'm not sure if that was responsive.
Well, the Supreme Court has never.
No.
The Supreme Court has never said it's beyond Congress's authority just because it's family law.
No. But the Supreme Court does often talk about the domestic relations exception and refuse to get to issues. And it's in the background of some of the other federalism cases. So if you look at Morrison, which was about Commerce Clause power, but having to do with domestic violence, part of sort of the background of it is this is an area we don't want to go to.
Let me, as a last question, let me pull in Brian as the one non-lawyer here. If we have this panel in 5 years from now, where will we be? You have a prediction on how many states are going to tip toward legalizing same-sex marriage? Is public opinion moving faster in some parts of the country than others?
There's clear regional variation out there, and although the rate of change is not as uneven regionally as I originally thought it would be. So, if we're in Massachusetts, we're in a very, very different position in terms of attitudes than, let's say, South Carolina, which, by the way, 10 years ago, even though Loving versus Virginia had been around for a while, finally the voters voted to get rid of its prohibition against interracial marriage and passed. And 40% of the voters actually were not in favor of getting rid of the law. So public opinion is one thing we've got to be careful about on it. I do think public opinion is going to be changed. It's going to continue to change. One thing that's very clear, each year we have another large cohort of 18-year-olds entering adulthood, or sort of adulthood. And And there's no reason to believe that the current rate of acceptance of same-sex couples among the young is going to change. And so even if nothing else changes, just the sheer demographic shifts will result in greater acceptance. But at the same time that's going on, there's a group of people who are changing their minds as well. What we found really interesting in our research is, I mentioned the exclusionist group, and then there's this group called the inclusionist group. And the inclusionist group basically, pretty much, if you think it's a family, it's a family. And they're 90-some% are in favor of same-sex marriage. This group in the middle, though, this quote we refer to as transitional or moderates, or if we use closed open, sometimes we use the term ajar. This group is changing really quickly. This group is really shifted from around 50-50 on same-sex marriage to about 2-to-1 in terms of same-sex marriage. So, in terms of political groups or leanings, there's uneven change on that. I'm not going to make a prediction what's going to happen with laws, because we know that laws do not necessarily, legislative action do not necessarily correspond with public opinion, and public opinion, as I noted earlier, may not even correspond with voting behavior. So I'm not going to say what's going to happen in terms of laws. One thing I will say is that the acceptance of same-sex couples and other, quote, non-traditional families will continue to increase, will just continue to increase.
You have all earned some food and drink outside for being with us today for this program. So there is a reception outside. Please join us for that. But before we do that, please join me in thanking you. Coming from Massachusetts, we have a gift from Maura.
Don't say gift.
Thank you.
Not a gift.